My name is John Capello of Jacobus and Newbitz, and I'm here on behalf of the applicants HRR Corp. and to present the application for an interpretation as well as the application for a use variance. I also, what I would like to do is present the information on both of the applications to you. I know you may want to deliberate on separately, but for continuity, I think it would be best if we go through and give you the whole story. I also have here with me this evening Timothy Mitz, one of the principals of HRR Corp., who will provide testimony about the expense to date that's expended restoring this facility and the cost as it relates to the economic feasibility of this development in relation to other uses. I also have the project architect David Menko, who will testify as to the improvements being undertaken right now and contemplated in the future that will be in keeping with the essential character of the neighborhood, as well as Karen Aaron, the landscape architect, who will also discuss the site features and how it is in keeping with the essential character of the neighborhood. And then finally, Mr. Nelson, the town of Monroe historian, will supplement my presentation as to the history and uniqueness of this facility. Many of you may have seen, I know there's been a lot of back and forth, there's Facebook posts, there's allegations, but really what we're here to discuss is the plans of my client to restore what is a great resource for the village in a manner that we believe will preserve the character of this historic structure and provide a vital use for the village for years to come, and really stick to the facts of the matter as it relates to the use of this building. So with that, I wanted to give a brief history. I'm actually not going to give a brief history of the story, but I wanted to discuss the actual use of the building immediately prior.
Would you mind moving it over at that?
Yeah,
so
sure.
everybody can see it, including the board.
And I also for each of the. There should be like which three, four, all three, four. There should be 8 there, yes, so it should cover. I hope there's one left. And I will be distributing quite a papers as I think. In the past, under the most recent owner of ARC, who ran this facility as a home for the developmentally disabled, as licensed by the New York State Department of Health, the first floor contained all of the common areas. There's a dining room, a living room, a wood porch, sit on both on the front and side of the buildings, a kitchen, eating area, recreation area, which was historically a billiard room, and a foyer. You'll hear testimony later about how this was used and is in almost essentially the same character as it was in 1903 when it was built. If you haven't had the opportunity to go through it, I would highly suggest. I just walked through it for the first time myself. The original wood floors are there, the original moldings. We have a video we can show at the end if you'd like, just to give you an idea of how unique this facility was. So this was used back in the 1900s as a summer retreat for blind folks, including Helen Keller, who visited the site often. And this was the area where they congregated. Most recently, it was used by AARC for the same purposes. The second floor contains 6 bedrooms, a shared bathroom, and access, each of the bedrooms has access to a flat roof. This is where historically, I'm not referring to the blind folks.
Mr. Coe, if I can just interrupt, how does this relate
This
to the
relates to-
application and the
because I
use
want
of
to-
premises?
What I'm presenting now is the position in the interpretation as it relates to the continuation of non-conforming use. So what I showed you on the first floor is the use will be a common area for the group of folks that are living in the home, just as it was used by ARC just prior to this use and Mr. Mitz's purchase of the property. What I'm showing you now are the sleeping units on the second floor, which were the sleeping units that were used and licensed for up to 12 individuals to live in a group home as licensed by the Department of Health on the second floor. Those 6 bedrooms will now be used by adult homes or senior citizens who need some care in the same manner as they were used before. There will be 24-hour person here, I shouldn't say a caregiver, but someone there to help and assist these folks in the manner they live, just as there was in the prior use for developmentally disabled. Same rooms, same areas. The original license, HRR, through their subsidiary, or not their subsidiary, through the operators applying for, would be at this time for 8 individuals, adult seniors to be occupying these facilities, and in the future up to 12, which would be the same number of developmentally disabled people that occupied them previously. This is the third floor plan. Now, most recently, ARC discontinued use of this because they couldn't afford the upkeep because it's a huge, substantial building, but that had provided areas for staff to sleep in or live in help. This will be used by Mr. Mitz as his residence, so it will be consistent with the single-family use, and it will also be used by Pamela, Pamela Lee, who is the applicant, who will be the operator of the facility. So the operator will be living there. There will be staff on the first floor, but there will be someone living there, sleeping there, to assist these folks in their daily life. So what I show that for, as I discussed, is to show that, and we have the site, to show this proposed to the facility as it operates in the building. This is the site of the facility, just to show you there's 17 parking spaces located as you come through the front porch in the foyer. There's a parking area here and a parking area here that has approximately 17 spaces. Those will remain. There's no work proposed to the driveway that served the site. No work proposed other than enhancing the landscaping, and Ms. Aaron will speak to that when we talk about the essential character of the neighborhood. So we're proposing no changes, no expansions, no additional disturbance to the site than existed as our pig used it previously. I'll leave this up here because what I'm presenting to you now are copies of the New York State Department of Health licensing for the art facility. As you can see from the series here, they were licensed by the Department of Health as an intermediate care facility for the mental retardation, but also as a group home pursuant to New York State Department of Health regulations. They received a certificate of need, which is the third document in the third letter here, that states that was for a capacity increase for the developmentally disabled services, and they were licensed to provide Medicaid and Title aid for up to 12 places as an intermediate care facility. Site plan for your record that I mentioned as well. next item I'm handing you is the initial application. The name of the home has since changed and it's undergone some review. It was originally referred to as the Lee Calvis Adult Home. Now it is the Rest Haven Adult Home, which is an application to the New York State Department of Health for licensing to provide care for adults. The care that will be provided to this facility will almost be exactly the same as that was provided to the developmentally disabled, which is a place to sleep, to live independently while having someone available there if you need help shopping, if you need help with a certain service, if you need a ride somewhere or someone to get you a taxi or Uber or whatever we will be getting out. There will be someone available to provide that care for you, to get you to a doctor's appointment, to call. So it will really be not a total care facility. It will be someone who wants to live independently, who wants to have a room. They will have meals provided for them, an area to eat, a refrigerator where they can keep some of their own items, someone to help them make sure their medicine is dispensed correctly, and someone there just to generally care, which is in essence exactly the same as the services that were provided for the developmentally disabled folks who were living there, who were able to live on their own, which is why there was a group home, which was the whole reason of the project, was to provide them some independence while still providing someone there who could give them a little bit of assistance that they need. So the actual use provided is essentially the same.
But is the adult use regulated and licensed
It
by
is
the state?
regulated, yes, that's the application I gave you. New York State Department of Health will have to license it.
And the Lee Calvis Adult Home Foundation, is that a corporation?
That is no longer, that application has changed, even in the initial application, but their Pamela Lee is the applicant, and there will be a corporation, I believe, running the facility. It won't be,
Will it be a non-profit or?
it will be a for-profit corporation.
You mentioned
So
the parking
it will
lot.
be taxed.
You mentioned the parking lot won't change, but will there be a limit on the number of vehicles on the property?
Well, 17 spots are there. The adult residents will likely have no parking spaces. There will be 2 permanent residents, so 2 or 3 cars for the permanent residents, and the rest will be for visitors or the 1 or 2 staff persons. So we think there is plenty of parking available. And it's similar
I
to
understand the amount of space available.
Right.
I'm saying, will there be a limit on the amount of permanent vehicles that will be on the property, or is it just?
if the board, yeah, well, no, we can accept a limit of, permanent, leave some for it if the board in its decision to issue a variance said limit 5 per permanent vehicles, leave the rest for visitor spaces, would certainly be something that would be amenable to. The next thing I've got is sure.
In Mr. Mitt's letter of May 9, 2017, through the mayor, it talks about permitted uses and people recuperating from illness and or providing community housing. Does that lead to probability of apartments or condos?
No, that, what you're referring to, I believe on May 9th, was what we had submitted to the board, because we believe this is a use that would benefit the board. What that is a petition to the village board to amend the zoning, because as I'll get to later, the comprehensive plan that the village recently adopted, one of the things they talk about is the need to preserve these larger historic homes so they're not cut up into apartments. Therefore, it states in the comprehensive plan, bed and breakfasts or group homes, and those group homes should be a use that is explored to help those homes continue. We petitioned, because there is currently in your code today a definition for convalescent homes, which is for recuperating of illnesses. So as not to totally rework the code, we used that definition, requested that it be amended slightly, and that the village board amend the zoning to permit convalescent homes as a permitted use in the SR10 zone, which is where this property is located, subject to certain conditions. That would be the cleanest way to do this. The village board has asked that we come here, and we certainly believe we're entitled for relief from this board, but the village board in adopting the zoning put whatever conditions. There's certainly no intention, and I can't say it strong enough, to do anything to alter the essential character of this. So it would be a one kitchen, common area group home. No intent to divide it in condos, which frankly, as we go through the use requirements, is something that your code today almost encourages, which is why we're asking for a use variance to allow us to exactly not have to do what you just suggested and preserve this as a 6 bedrooms on the second floor, 3 bedrooms on the third floor area of common kitchens. And that definition would allow this to occur, but it would be an action that the village board, we believe, should take. But tonight we're here.
And right now, SR, it's only permitted, convalescent homes are only permitted.
Convalescent homes are only permitted in the SR20, and the definition doesn't specifically. While I think you could do an interpretation that this type of use would fit in that definition, we ask that it be clarified so it specifically states that adult residence is included with that. That does provide some limited care.
So, this breaking up into smaller apartments that you quoted, is that based on it being an overlay area?
This isn't an overlay. I'm going to say two family is permitted in the zone, and I'll go through to show why that doesn't make economic sense.
And just to clarify what Mr. McCarthy said a few minutes ago, he wasn't suggesting it, he was just asking.
Yes, and but I was explaining why.
He didn't suggest, he was just
That
asking.
under that definition, other uses may occur. We wanted to use what the village had, so we weren't creating something totally new, something that would fit, something that would allow this to fit in without being a heavy lift, and something that would be consistent with the comprehensive plan. To the decision, Mr. Cox, in reviewing this application for a land use determination, stated that the ARC facility was a permitted facility under as a single-family home. Now, the law that Mr. Cox, we believe, was relying upon is the New York State Mental Hygiene Law, Section 41-34. And that law does say that if certain procedures are followed, that a group home specifically for the developmentally disabled is considered a single-family home under zoning. But it does say if those procedures are followed. Now, I provided you with a copy of the New York State Mental Hygiene Law, and if you look at it on Section C, it requires that in order to take advantage of that procedure, that the sponsoring agency notify the chief executive officer of the municipality in writing and include in such notice the specific address of the site, the type of community residents, the number of residents, and the community support requirements of the program. And then it talks about other requirements that would go into that letter. Once that letter is submitted, 40 days before the proposed occupancy of the developmentally disabled facility, the municipality would have to express whether it was okay with that or if they had adjustments to that. If they didn't express it, it was approved. If the procedures of that law were followed, then Mr. Cox is absolutely right. This would be considered a single-family home. However, a review of the village's record disclosed there is nothing in the records that show that letter was ever filed, nor did anyone at ARC know of any letter or any correspondence going that way. So
Do you
therefore,
think there might be some reason for that?
what?
Do you think there might be some reason for that?
I don't know.
Well,
I mean,
4134 is the Padavan law,
yes.
okay, which is not retroactive, and was effective September 1st, 1978,
Right.
correct?
Yes.
What if Art moved in there prior to that date?
If they moved in there prior to the date, even more goes to the point that I'm about to make, is that this facility was entitled to go there, not under the provisions of the Pathfinder law, but was entitled to go there either as a continuation of a non-conforming use from the use as historically was for a school of the blind, and then for an engineer's occupation, which is a retail use, which may not have been permitted, or as a medical facility, which I will provide you with the old zoning.
This case law at the time, prior to Padawan, which stated that these type of facilities were single family facilities that were allowable in these zones, then this would have been allowable prior to Padawan and without the letter being.
Then there would have been no need for the Padovan law, but there is a Padovan law. And that's what the determination we have from the code enforcement officer states, that it was entitled to a single family. And prior to the Padovan law, how do we know what group residence? Because group residence, what we are proposing here is a group residence for people who need some assistance. So while it is not under the mental retardation, and excuse me for use of the word, but that's what was used in the code, or developmentally disabled, that is specific to the category. Prior case law would have been more general, would have said a group home could occur, and if that facility was a group home as a general, then what we are doing here and proposing today is consistent with that pre-existing non-conforming use and should be entitled to the same deference that the facility just prior to use there, because as I stated, it is a group home. It's considered a group home under New York State Department of Health law. It's licensed by the same agency to operate. It just does not have a specific law, such as the Pavden law, that says it's a single-family home. But if you go by prior case law and generically say group home, then this is a group home, then this would be entitled to continue as a pre-existing non-conforming use.
Are you saying that the use of the premises for adults with, adult senior?
Adult care, living as a group, living independently
You're
as a
saying that's
group.
considered a group home?
It's considered a group home licensed under, it's considered an independent care facility. It's just not licensed, it's just not protected under that specific code of the mental hygiene law. It's still, they're still living as a group, they're still licensed by the Department of Health.
Yeah, but are they considered group homes, or are they
There
considered
is
adult
no-
care
there's no-
facilities,
there's no-
assisted living facility?
They're interdependent, independent residences is what they are. There is no real legal term, group home. That's like a zoning term that's been used, but the licensing, if you look at the licensing for, that I put in,
What section of New York State law is this type of facility licensed under? Is it mental hygiene law?
it says, this is the
social
letter
services
of
law?
April 2nd, 2002 to ARC. It says, this is to inform you that the New York State Department
I'm
of Health.
talking about the
But I'm-
proposed use.
But you're using the
When
word
I asked you a
group
simple
home.
question, what I just wanted to know was the proposed use that Mr. Metz wants to make of the house now. What section of the law is it licensed under?
It's licensed under the CMFR, the federal regulations, the immediate, as an immediate care facility, which if you look in your August 5th, 2002 letter that I submitted as part of 2003 for ARC, ARC is in compliance with the regulations for intermediate care facility.
I'm not interested in the ARC, but I'm asking is,
But this is
particular
an
use-
intermediate care facility for adults. The
I just want to ask you,
Yes.
under what section of New York State law is it licensed under?
It's
That's
under.
all I want to know.
I don't CFR exception, I can get that for you.
Well,
It is-
that's
it
the
is an
state law,
intermediate-
not
Yes,
federal law.
intermediate care facility, it has the same, similar designation, I don't want to say the exact same provision, but it is an intermediate care facility, that's correct.
All right, just before we get too far in, I just want to do a little housekeeping here. We're getting a lot of exhibits into the board, and I just want to make sure that they're all properly indexed. So let's, just for our record, let's go back. The first thing you introduced was a set of floor plans of the residence showing the 3 floors. I'm marking that into evidence as Exhibit A. The next exhibit is the site plan that you have on your easel. I'm marking that into evidence as Exhibit B. Yeah, no, we do. It's the same one. That one's just colored.
Is this? Okay.
Okay. Set of 3 letters from the State of New York Department of Health. The first one is dated August 5th, 2002. The second one, June 30th, 2004. The third letter is from the Department of Mental Health. One exhibit, yes. Dated January 16, 2014. These were handed in as one exhibit. I'm going to mark them Exhibit C. The next exhibit was the initial application to the State Department of Health under the project name Lee Caldis Adult Home. I'm marking that in as Exhibit D. Then we had a copy of New York State Mental Hygiene Law, Section 4134, that I'm marking in as Exhibit E. And then we have this new exhibit, which is, appears to be a bunch of pages from the zoning code. 1, 2, 3, 4, 5, 6, 7, 8 pages. And I'm going to mark that in as Exhibit F.
And that is from the 1967 zoning code? Sir?
Yes, it is.
It was 8. 1, 2, 3, 4, 5, 6, 7, 8 pages. We're looking at.
Yeah, those are provisions of the old zoning code to say that it could have been, we believe it's an extension of the non-conforming use, and I would put in the record that it's, while you were giving that brief respite, it's 14 NYCRR 686-3.
686-3.
Lowercase a 3.
And that's the section of law that this facility,
This is a
that's being
facility for
proposed, would be licensed
an
in.
individual. They have a common application for everything, but it would be for an individual resident alternative, which are designed for people who do not routinely require on-site clinical services. All people residing in an IRA are encouraged to actively participate along with their families in the development of their program plan. Through this participation, people exercise the opportunity to shape their own futures by deciding what they would like and need to learn. They offer 24-hour-a-day supervision from trained staff. This is for what the applicant is proposing is that same type of service, and this is for adults only, so it wouldn't be developmentally disabled, but it would be an individual residential alternative for adults in need of assistance.
So
Such as by the state.
we're just saying is this particular section is section for a developmentally disabled individual?
Not developmentally disabled. I will clarify it there because they asked you to propose a common application. So in this common application, it's not necessarily developmentally disabled, but it is for a group home.
proceed with Exhibit F that you submitted to us?
Yes, Exhibit F. 75 district. As I said, our position is that it's a continuation of the art use that is permitted, and that at that time in the R75 district, if you go to
Just a second, you
Yeah.
say continuation of the art?
of the group home or independent residence facility that was
But this
located
is
there.
the 1967
In 19,
code.
yeah, this was the code that was in effect when ARC began operation in the facility. So this would be the code that would apply to their use of the facility.
Are there any COs issued for this use? So you're saying this was established prior to 1967? The use
No,
of
no, no, no,
for dis-
it was-
for mentally disabled?
No, the zoning law was established in 1967. The use was established in just early 1978 or 1979. We don't have the exact date, sometime in 1978.
So use by mentally disabled? 67 code was in effect then?
Yes. Now, this property was located in the R75 zoning district at that time. At that time, the special uses for the R75 referred back to the R175, which permitted general, medical, and surgical hospitals, which could have been a,
This is special exception.
yes, it was a special exception use, and there's no records of anything, so we are just providing this to let you know that it's possible it could have been proceeded under that, because there's no record that it was allowed under the Pavlin law proceedings, and if it was, and if it was prior to Pavlin law, or if the procedures weren't followed, it would have been occupied as a group home or an independent care facility, not necessarily under the Pavlin law. If it was provided under that, then we are doing, our position, we're proceeding in the same manner.
New York State, ARC, it's a state agency.
Yes, it is.
Okay. What about sovereign immunity? Wouldn't sovereign immunity oversee?
If sovereign immunity oversaw it, then why is there a Pavlin law? Why would they have the need to adopt
Well,
it?
For private
If
facilities?
it's a pattern, if the Pavlin law did away with sovereign immunity, I'll agree. But if this is prior to the Pavlin law, then sovereign immunity would take effect.
There are group homes all through the region where and we can get testimony from where they follow the procedures for Pavlin law. They didn't follow it here because it may have either been before or they didn't need to. But if ARC was located in a facility in a community today, they would follow the procedures under the Pavlin law. If it was
But if it was before sovereign immunity,
sovereign
would take
immunity is
effect.
sovereign immunity. If there was sovereign immunity, there wouldn't be a reason to adopt. I don't want to get.
Yeah, I don't want this to be an argumentative proceeding here
Okay.
over laws that, we're not a
Right.
court,
Right.
quasi judicial, but we're not a court, so
I want to respond to your question.
I just want to point out for the record, I have a copy of a CO which I believe is for the structure that was issued on August 1st, 1977 for a 10-bedroom year-round single-family dwelling structure situated in R75 single-family dwelling zoning district. And it was issued to John F. and Helen Lance, owners.
That was the engineer who owned the property prior to selling it to us. He had his engineer's office there.
That's the last CO that we have in the file on the structure?
Yeah.
So is it possible if it was converted to a group home for the mentally disabled, it was done without any approvals from the village?
Well, looked at it, didn't need it because it was continuing, or if it was a group home, it wasn't covered by
It
that.
wasn't continuing. If the CO was issued in 1977, you're a single-family home, I don't
What
think
there
this was
is,
continuing.
well, then if it was allowed under a group home, but not under the Pabst law, under the prior case law that says group homes for those facilities are considered a single-family use, then I think we have an argument that we're doing the same thing. If it was Pabst law that says it's specifically for developmentally disabled, which there is nothing in the record that shows it, then I don't have an argument. Then it was,
Resided at this location and had a professional office.
Yes, he did.
Correct. And this would show by what you gave us, 47.9 says permitted use, single-family detached dwelling, and one of the accessory uses that's allowed is the professional office.
home occupation. Yeah, I'm not arguing that he wasn't.
Yeah,
But but I don't know how much area he occupied, or, you know, what he doesn't, there's nothing on that CO that indicates that it's a permitted home occupation, because
It's for
there
a
were some-
three-bedroom, year-round, single-family dwelling structure situated in an R75 zoning district. Now, Jack Lance, John F. Lance, and Helen Lance owned this property since 1968.
yes.
Okay? And ARC didn't come in until, according to your statement, 1978.
Yes.
So for at least 10 years, it was a single-family residence for which John Lance lived there and had a professional office, which was allowable under the code that existed at that time.
Although it's not referenced in the CO, and it would have been referenced in the CO because you would have to demonstrate the percentage of the area of your facility, because that's another definition that is in there, that was occupied by the professional office, because there were limitations on the space. You could only use less than percentage of the first floor. There were limitations on the number of employees that you could have. So there is no documentation in there that, but we understand that he did have an office, and I'm not.
And it may not have applied for it.
And he lived there.
He may
and
not
he
have
lived
applied
10
for the
bedrooms.
office, though, but he definitely lived there as a CO given for living there, so there's no continued use of anything prior to that.
Right, so we're looking from the time the group home came in to say we're continuing that use under the same ambit that they would have been
Assume
allowed.
they were given a that use.
And assuming that John Lance owned this property until 1986, then he was the landlord for ARC for a period of
Yes,
time.
it was. That's my understanding. Now, the next exhibit I'm giving you, I have these numbered, so what I'm giving you is not dispositive, but once again, it just goes to, it is relevant. It's not dispositive, but it is relevant, and that is the county assessment listing and the, both prior and present, which both list the facility currently at 236 High Street as a health building. So it's not listed as a group home, or, and I understand there'll be a letter saying that it's not dispositive, but it is, yeah. But, and I am not arguing that it is dispositive, but in context of everything in making your decision, I believe it is relevant that this building was considered as such.
What was it considered as?
It was designated as a health building, 642.
Well, I'm just submitting a document from the town of Monroe.
So this was issued by the county?
No, that was
That's how it's classified for assessment purposes. It's off the county records.
Yeah, but this is from the county website. I'm looking at the tax
The second one.
tax roll
The county.
from the town of Monroe.
Okay, that's the town of Monroe's assessment record, which also listed as a home for adults.
AHRC.
And you're conceding the fact that in the letter from April McDonald, the assessor to the village of Monroe, that the codes have no bearing on the building or zoning ordinances.
Yes, I said it's not dispositive, but in context of everything of how it was how it has been considered, how it has been assessed, how it has been taxed, that is relevant given all the ambiguity that you have before you. And that's really where I'm going to end my presentation on the part of the interpretation is the Allen versus Adami case.
Just
which-
before you
Sure.
proceed, I just want to note for the record here that I'm marking this other exhibit, and I'm marking it as Exhibit H, which is a letter from April McDonald, assessor of the town of Monroe. Which you're familiar with this letter.
What's that? Yes, yep.
Anybody have a copy of that letter?
It wasn't given a
No, but I'll just read it for you. I'd like to clarify that property class codes are used to classify property based upon the primary use of the parcel. The codes have no bearing on the building or zoning ordinances. After speaking with New York State Office of Real Property and Tax Service, as well as other assessors in the county, I found that the most appropriate class code for this property was a 642 health building. The reason for this is that all other, quote, group homes / assisted living facilities, close quote, in Monroe and in the majority of Orange County use this code. One of my primary jobs as the assessor is to make sure that the assessment roll is uniform. They're used to classify the primary use and to value, quote, like properties. Very true, yours, April McDonald. Sorry.
And is it your position that you're going to obtain a 642 for this particular?
That, I think that would probably be the appropriate designation.
What about 633, which is homes for the aged? Why
Well, it
would
would be a health,
why would it be
building.
633?
My position, well, the assessor will determine what it is, but it would be a licensed facility, it would be a, on the tax roll, and we believe we'd be giving care. If the assessor thinks it's an aged building, once again, that was presented, once again, not as dispositive, but as relevant information given the context of how this building was historically looked at, given the fact that your records are devoid of any real indication of how this was accepted and located, and given that we believe we're continuing the same use. Now, what I would cite you to is the case of Allen versus Adami, which is a New York State Court of Appeals case, which states that when there's an ambiguity in a zoning law or an ambiguity in the records, the presumption goes in favor of the property owner because zoning is in derogation of property rights. That is case law, it's Court of Appeals law, and I think everything we've shown you here has shown that there are some real questions about this in, how this was actually located, and it can be a logical conclusion that you can come to that would support a determination that this is a continuation of the pre-existing use of a independent care facility, group home, giving care to individuals in a community setting and giving them freedom and accessibility. Not under patent law, but just giving that context of everything we've submitted, that is a logical conclusion that you can come to. So that's the interpretation. So now I will, the use variance, because we believe in if you don't grant that interpretation, which we think we've created a record that would allow you to do so, if you so desire, when you look at this property, given the history, given the context, given the zoning that is there, that about the only use that you could logically proceed in this house.
Was that financial
Yes, we are.
information?
Yep. This house, first of all, what I am presenting first, prior to the financial information, that the financial information is coming, is a letter from the Office of Parks and Recreation to the EFG area. Just confirming that the property is eligible not only for the National Historic Register, but for the National Register of Homes, which I don't have because I wasn't able to print out in time, is a letter that's on Senator Schumer's website today congratulating and supporting this designation and the preservation of the the houses. The second page in that, I underlined, it kind of goes back a little bit, but we know we do have a problem with Mr. Lance, but it states on the second page, this house remains an impressive specimen of early 20th century domestic architect rendered in a distinctive colonial revival vein, and it maintains salient history associations with efforts to promote the welfare of the blind by the Miguel family, Helen Keller. It survives largely as built in 1903 with minimal alterations. So this is a amazingly unique building. And it was also
Last time I checked, the unique building was not a standard for the use variance.
you should check again because it does need to be unique property. It's one of the 4 standards that we're not trying to be argumentative, but it is.
Okay.
So what you're also saying is that the part where you wrote the building was never designed to be utilized as a single or two-family home. You're not deleting.
Yes.
That's what I thought.
Just as a correction, it says the alleged hardship related
Yes.
to the property in question is unique, not
Yes.
that the property itself is unique.
Well, the hardship is unique because it's a historic, unique property in the zone. And the other point I am making that was already actually made for me, thank you. This is the application, just so you have the information. And the information is when this facility was designed, and at the time it was built, Monroe was certainly a different area. It was part of a larger Miguel estate, which some of the documentation, if you look in there, shows that it was located on 225 acres of land. And it was part of several homes. It was a vacation retreat. It was in a different age in America. And it was in a different age here where these large estates with large areas of land in communal living were a viable use. Over the course of the years, the property size diminished. The last time it was subdivided actually was Mr. Lance, who subdivided the land back in the 1970s from to make it a 2-acre parcel. So what we're left with is a 10-bedroom.
What was it in the 70s when he subdivided down to a 2-acre?
I don't know exactly when he subdivided 5 acres. But it was on a 225-acre estate, and Mr. Lance subdivided it.
So the American Foundation for the Blind in 1968 sold,
To the Lances.
no, he sold to Henry Ryan and Anne
Oh,
Ryan.
Ryan,
And then Ryan
sorry.
sold to Lance.
Yes.
But what Ryan sold to Lance was 3 acres.
And then it was subdivided down.
And that was subdivided to 2 and 1, Lance 2 and Lance 1.
So most likely the one that got it for subdividing.
That was 1974 that he subdivided.
Around that time, yeah. And operating a business out of it, you know. And, but as time has gone on, the property became in a disrepair. And what I have now is financial information. And there's a letter from Mary Lively, who is here tonight, that this property was listed by our, since 2008. It was listed as a single-family home, which is in this letter, and that listing expired in 2011 without any buyers. Now, I have another exhibit that will show you.
Can I pause you for a second?
Sure.
That's a housekeeping question at all. Is this an exhibit?
Yes,
Okay.
yes.
What exhibit?
So let's go back.
Yeah,
The
National Register.
last document, the National Register of Historic Places registration form, I marked it as Exhibit J. And this letter from Remax dated July 10, 2017, and the attachments is being marked in as Exhibit K.
Wait, where was I? I mean,
I was the letter from the New York State Office of Parks and Recreation and Historic Preservation.
Okay. I'm just trying to keep this all straight here, that's all.
All right,
It's okay.
I'm doing my best.
And I thank you, and I know I'm presenting a lot of information. below the letter for Remax, which state they were unable to sell it in the listing as a single-family home. They could not sell it until it was listed as a commercial use, is a letter from Gemstar Capital, a financing facility. This letter is from a Raymond Knox, who is the managing member. And he goes into the reasons why it's very difficult to obtain, where a bank is not necessarily willing to give financing on a home like this because of its size, of its uniqueness. There is a, if you go back to the second floor, there's a sink in every bedroom. I mean, it was just designed in a different time. They were unable to get appraisals that a financial backer would be able to lend for purchase as a single family, and he concludes that it was a white elephant that was too unique for any lender to go and was only available for financing when it was sold as a commercial, as a group home. The third piece of this exhibit are the what do you call it, Willow listings. Zillow. Home was originally listed at 1.1 million, then reduced to 989, reduced to 849, reduced to 750, reduced to 695 to 599, and then finally no longer listed as a single family and sold for commercial. So it.
Howard, this sort of seems to take into account the housing prices very poor, and then the listing of the high prices. Building as a single family doesn't mean.
But again, what I'm getting at also is the fact that this is a AHRC putting it on the market as a single family residence. Doesn't that show that they thought they were single family residents?
No, they talked to a realtor, and the realtor thought they would get the most money as a single family resident, and they were wrong, because there's no market for a single family resident.
So there's some kind of fraud here.
What?
They're selling it, AHRC should know what they're selling, and they're selling a single family residence. Because of the fact that under the law, they consider themselves to be a single family residence.
They could consider themselves as, they could sell it as a single family residence. You could sell something for whatever it's permitted as. That doesn't mean they weren't licensed and had a pre-existing non-conforming use as a group home, but we're trying to sell it as a single family residence and couldn't sell it.
But I think what Howard's trying to point out is that if there was another use for it, why wouldn't they also list it as that concurrently?
Because they talked to a realtor, and the realtor said, we think we could get the best price as a single family residence, and there weren't a lot of people standing around saying, we want to do a home for the developmentally disabled or for a adult use.
Not suggesting that not be listed as single family residence, but if there was another available use, it could be listed as that as well.
That wasn't, for whatever reason, they listed it as a single family, and it couldn't,
And also the time in which it was listed too, at the price, I mean, no houses were selling. The hardship seemed to be nationwide at that time, not just for this particular house.
and if you looked at the history of it, part of the reason Art had to stop using the third floor is it's not only a white elephant. I mean, it needed substantial upgrades as to utility, as to heating system, as to upgrades to the building, and which is why I'm getting into the next financial, is what it cost once it was sold for $450 for the commercial purposes, what the investments that have been made to date to upgrade this into a habitable building.
Just of the building, on the house?
Yeah,
December last year.
December 2016? December, right?
So September.
September.
Yeah, 19.
What's the last one you gave?
Now that cover page, I'm going to jump back to Mr. Nitz later after my whole presentation, so we're not jumping back and forth, and he can present this in a little more detail. But this details the expenses he needed to begin the upgrades to the house, because one of the things that Art did is, you know, they weren't great in the upkeep of this facility. It needed substantial repairs, not just to restore the historic character. There was a lot of neglect to this facility, which may be a reason a lot of, I think, anyone who may have an issue with this may be harking back to the history of the neglect of that facility. I mean, the building is in need of care. I'm going to summarize this quickly. It shows the acquisition price and closing costs, what HRR has spent to date, which is $240,000 plus an additional $246,000, which will be necessary to complete the renovations. Much of it, which will be on the exterior, which is very much in need of some care. The second page we provided you is the cost to finish in total price, assuming it's $965, with the carrying cost of $7,200 a month. That's just on the current mortgage, which is low. It doesn't take into account all the other loans that made out to it. Brings it to $7,200 a month carrying cost for this. The family is approximately $5,600 based upon a review of the area.
Do you have backup for these numbers?
Somewhere, yes.
You can submit to the board copies of invoices.
Yeah. The last one is a report prepared by Ms. Lidgy. There's not a lot of single-family residences around, but it shows you some of the rental prices. And you're looking at $2,800 for 2,098 square feet, 4 bedrooms, 28 for
Who's Mary Leachy?
She's a realtor with, her name's on your first page of the letter. She's a realtor with,
Just for the record, the financial information I marked as Exhibit L. The financial information. Just marked as Exhibit L.
Just to clarify, this one was what exhibit? The one with the Remax balloon on the front?
Okay.
Okay.
That's what I thought.
no, 18 is the total. We also provided a analysis of the two-family residence, and the two-family residence would, as far as the interior, and really have a look at the floor plans, and if you allow us to show us the video of what this facility looks like. To convert this into a two-family would really be a problem. You have to put a wall through the middle of the facility, you have to put in another kitchen, you have to rip out piping in walls, and not only at a substantial expense, it would knock the home off the National Register, which would, like I said, be a shame. And the rents for a two-family, the estimate is be based upon what we gave you for 2,800 square feet would be about $3,000, so that would give you $6,000. So you'd have to take the $968 plus the additional expense to convert it, and it really would, you would lose money. It just wouldn't make sense to do it.
Having gotten the okay from the National Register of Historic Places, does that eliminate any subdivision on the part of this particular property?
It would require a heightened review. As I was standing on the property, it doesn't. You may lose the designation.
So the designation does not preclude subdivision, but subdivision would preclude designation.
Yes, and the designation as part of any seeker review that you undertook on the development. As I was standing on the property just before the meeting, I was looking at the development, the new development on the side, and said it's funny because if we were on the National Register when this new development came in next to this, that new development would have had to examine the impacts on this home on the historic register, and it probably would have been designed not quite as close to the property line. And I don't know if it's in the record, if it was taken into account.
So you haven't given us a total as to what he might have obtained if he divides it into two 1-acre lots and sells
Not yet.
1-acre lot?
Not yet. I will discuss it. I would have to get you figures if that's what you want to see. I need, want to present, and certainly questions that we can supplement the record. The other use that is permitted in the zoning district, permitted as a right, is religious assembly. Religious assembly would also take changes to the facility depending on the type of religious assembly, but the most difficult aspect as it relates to that, and this you have as record that I would just want to put in the record, is for religious assembly you require parking area of 0.43 spaces per attendee. So based upon being able to provide 17 spaces here, you'd probably limit that to 38 people attending a service. Now, there is RLUIPA, which would probably require this board to grant the variance, but we're only required to examine what the permitted, whether there would be a reasonable rate of return on permitted uses. If a facility coming, they'd have to, once again, knock a lot of the vegetation down, result in a loss of historic designation. Know if there are any religious assembly, that have the funds to pay upwards to $1 million or more to get the return on investment for this facility. So based upon that, we believe.
So wait, I'm saying that this cannot be used as, religious use is a permitted use in the
Yes, it
zone,
is, yes.
and there's no way that this could be used for religious use because of the parking requirement.
No, I'm not saying that. I'm saying to get a reasonable rate of return on the investment so far of $965,000, you would have to encompass the repairs that will be needing to make to the site beyond the $965,000, which would be removal of a lot of the vegetation, blacktopping to put additional parking going through. While it is a permitted use, you would still have to go through site plan review for that use, which would be quite costly, and let's face it, and potentially a variance which would run you up to well over $1 million. We don't believe the market is there to get that $1 million.
To me, that's speculative right now. If you were to produce evidence saying this is what it would cost to renovate the property, to do whatever else, this is dollars and cents proof.
Yeah.
You know the standard for use variance very well. And you've got to show by dollars and cents proof. It can't be speculative. It can't be, I don't think, it can't be, I assume that we're not going to get it. We need to know, dollars and cents, hard proof that you cannot use this for any use allowed in the code.
And in that respect, in your papers, you don't mention one of the possible uses, since Mr. Mitz will be living there, and that's a bed and breakfast.
That's my next, well, when I filled in the application, the bed and breakfast was not, and it's also an accessory use, which is maybe not a permitted use, but the requirements for bed and breakfast, one, limited to 5 bedrooms, and this is a 10-bedroom facility, which would
Require a variance just for the bedroom.
require a variance, which a use variance, you're only required for permitted use, not to demonstrate that you couldn't get a variance if you required.
An actual person or an accountant. I'm a little confused about this. We went for a home for the blind, which I assume those persons were supported by the state, or the county or both. And then we moved to the developmentally disabled.
Right.
And I assume the same type of thing prevailed. Now, when we are moving to what you're proposing, and you're talking only about 12 people, and you talk about the total cost of developing this property, I fail to see how it could not be run except in the red.
It's because of the licensing, because it's a care facility, and it would be contingent care and additional care. It would be, there are rents that would be allowable, that would, because you would rent by bedrooms, so you'd have 8 renters paying for the care and for the continuing care. So
Well, how do you plan to charge these fees?
It would be charged rent, right? Yeah.
Will they lock their doors to their bedrooms?
They would be, it's their room, they use it, that's what they're there for. If they want to feel secure that way, that's their choice.
I mean, are there locks in those doors? These
No,
old historical-
everything is passive.
So
No
those old
locks
historical
running.
doors would have to have, they're allowed to put locks on the, that doesn't change the historical value of the, or the registry of this building?
No, well, the big change that will change this property is the elimination of walls, floors, staircases, flooring. That's gonna change the historical, because there's so much in this house that, you know, remember, it took us only 4 months to get the state of New York to give us what we wanted. And now they've moved the file, not from only to the National Registry that we're on now, they've now moved it up for recommendation as an actual landmark in Monroe.
So you're saying like you spent a lot of time and money restoring this building, and you're saying that they can put their own locks on these doors and drill whatever kind of, you know, stuff?
The lock itself won't make a difference. If I start tearing walls out, that makes a
Well,
difference.
I understand the extent where a difference is made, but it seems like there's a lot of little things and destructive things that could happen throughout this place that could, you know, sort of diminish this property. So I mean, is there something that, I know in the historical sense of the registry, there's nothing to prevent this from, but if you want to put this forth as a building that's got all this historical value and you spent all this time restoring, are there going to be restrictions upon this building and what people can do to this, or are you just going to rent it and forget it?
No. It's gonna be, I'm gonna have to make sure the building stays the way it is. I do not want to change, I don't want to subdivide the property.
I'm kneeling down.
I'm throwing the whole picture in and out. What I'm saying is that the building is, if you walk through it, you would understand, the building is beautiful the way it is. There's no reason after 114 years to throw locks on doors or anything else like that, unless there's a reason I'm given that's a valid reason for doing it. I want to maintain it as it is, and I think when you talk to Jim Nelson, you'll understand, because he's been watching me as I've been developing the property and keeping it the way it's always been.
I just want to point out,
Yeah.
we have a room full of people. I'm assuming
Yeah.
they're members of the public that want to speak out on this application. I'd like to get through the rest of the application or the presentation by the applicant, and so that we can hear from the public, because I don't want to have these people sit here and not be able to comment.
I
So,
appreciate that. There's a lot of
no, he needs to finish his presentation,
On bed and
so
breakfast,
I would appreciate it.
I understand you want more financials, but I can tell you based upon occupancy rates, based upon 5 rooms, based upon it having to be accessory to a single-family use, which then gets into how much floor space am I going to use, the whole first floor, the way the building is laid out, it would be hard to make this accessory to a use, but I'm going to get you financials.
It's speculation, so let's...
This is, now I'm on to the next issue. That was, the other uses are non-commercial recreation and agriculture. I don't think I need to go on financials that if I got this for non-commercial recreation and could not charge, that it wouldn't be able to make a reasonable rate of return on $1 million investment, or do you want financials on it? I don't know how to, I don't even know what the heck that is. Give it to the state for a park?
I think you should submit whatever you think is best to prove your case, and the board will take it into consideration.
I would then posit that if it's not commercial recreation, that means I can't charge for the recreation. That means that I would not be a reasonable rate of return to convert this to a public park. Agricultural, I don't think I could get on 2 acres of land. My client could get a reasonable rate of return to sell to someone to grow crops on the agricultural, unless you use, where it's a pretty large basement for a cannabis growing facility would be about the only way I could see making money on agricultural. So that leads us to whether the... Yeah, I don't know. What I'm saying is I don't believe there is any way to make agriculture. Now, we get to the essential character.
You submitted this.
Yeah, that's the...
What's the purpose of this?
That's to show on the issue of uniqueness, that those are the 5 homes in the area that they subsequently told us are over 5,000 square feet. So there are not a lot of homes in this area that are this size. 2 of those homes are on substantially more acres. I think one is 13, one is 19 acres. So that goes to the fact that this house of this size on this small lot, the hardship is unique in trying to market and sell this lot for a single family or other types of use. Now the next one handed is when we go to the next one, will it alter the essential character of the neighborhood? We believe that restoring this house and leaving it as one unit functioning as a group facility, maybe with locks on the doors, but otherwise retaining the historic character, will improve the character of the neighborhood rather than alter the essential character. Frankly, the uses permitted, which would be converting it to a two-family or providing traffic associated with religious assembly or a commercial use, would have a greater impact on the essential character of the neighborhood than the use proposed. And I provided provisions from your comprehensive plan that show that your comprehensive plan actually suggests and promotes the restoration and use of these historic homes and not cutting them up into smaller units, and promoting them, and also specifically encourages and recommends eliminating two-family uses as permitted or special permit use. This is on page 37. Outside the multifamily conversion overlay zone as a way to promote and safeguard the area, and also to encourage alternate reuse of large homes. It does say in the North Main Street area, but this is actually the largest of those homes in general the area, by allowing additional reuse opportunities, including professional offices and group homes. So that is recommended by your comprehensive plan as something that is laudable, and we think not dividing this up, dividing it into 10,000 square foot lots, and probably then requiring the demolition of this home is not something that is good for the character of Monroe. And I don't think anybody would be happy that that was the end result of this.
Just for your clarification, there was a zoning code that was passed after the comprehensive report, and there are no more multifamily conversion overlay districts in the village of Monroe. So I don't know what this means.
It said take out two families. Remove two family for the permitted use in the R2. But really what you're saying is the zoning you just adopted doesn't comply with the comprehensive plan you just adopted, because that's reads from the comprehensive plan that says eliminate them from everywhere except the multi-family conversion zone. So if they eliminated the multi-family conversion zone but didn't eliminate the two-family, then they really didn't follow the recommendations that.
Well, they didn't eliminate the two-family where?
It says eliminate the two-family from everywhere except the multi-family zoning district. They didn't eliminate the two-family from this SR10, and it's outside the multi-family zoning district.
Two families are not permitted in the SR10.
You deducted.
Under the new zoning code. No.
So then I just didn't have to go through that analysis on the two-family, but it wasn't clear from the law. The issue of uniqueness, I will allow the town historian to speak to that. I believe I spoke enough. And the last item I wanted to give and discuss with the board is the issue of self-created hardship. I'm providing a letter, and Mr. Mitz will also provide a bit of testimony relating to the history of the use. Now, the technical provisions of the law require that you're imputed with knowledge of the zoning. So Mr. Mitz did buy this property, but when he bought the property, he had made a request for a land use determination regarding that was in March of 2016. He had to move on the contract by April. He hadn't had a determination by then, so he signed the contract to purchase. Then, as discussed in discussed in Mr. Krogan's letter, and as Mr. Mitz will discuss, he based it upon the fact that this was a group home and it could be a continuing non-conforming use. When he got the determination, he has his right to do, appeal to this board for an interpretation on that determination. Because of the moratorium, he was delayed for over a year. From finding that final determination, he was required to close by terms of the contract.
But he had the
So they closed.
interpretation.
He appealed it as his
But
right.
he had the interpretation at that point.
He didn't have it when he signed the contract, but he did have Mr. Cox's determination, which he disagreed with, and had the right under law to appeal it under the law.
I understand that he has the right to
Yes.
appeal, I just want to confirm
And I'm going to cite the
that he
case
had
law.
the
Yes.
determination of Mr. Cox
Yes,
at
he
the
did.
time.
Yep. I'm not going to dispute the facts, but my position is that he didn't have a determination from this board. There is case law, Center Square Associates, to the City of Albany, which is a third department case, which I'll provide to your attorney, which states under the circumstances a board can have rationally decided that the hardship was not self-imposed if the applicant was under a good faith belief that the property could continue as an
What's the site?
case 19 AD 3D 968. It's a third department case.
The name of it again?
Center Square Association versus Board of Zoning. Here you want that. Will allow the public, we understand, and we certainly ask the board that after the presentations are made, I've heard some of your comments, we'd like to supplement the record and would ask that the board keep the hearing open so we can respond to some of the concerns and comments I've heard you raise with additional information.
So before you present your witnesses, you want us to...
We're going to present the witnesses, I'm going to let you, I'd like to present the last two
Witnesses
witnesses. So with that, I am going to,
Just before we go on to that, I understand from talking to council that when you initially filed this application last year, it was under secret, it's a type 2. But since you've amended it to request a use variance, it now became an unlisted action, and
The SEA actually
Yes, right.
updated to reflect this application.
so you need to, so we can't do anything anyway, because we got to deal with secret until we get an amended environmental assessment form. We can't do anything, so if you can submit that.
yes, certainly will. Okay, with that, the first person I will introduce.
Yeah. Okay. We're just going to stand in recess for about 2 minutes.
Okay. Thank you.
Property, Charles McKendrick built his home in Monroe in 1902. He was a hops merchant and broker from Westchester County. He built his beautiful home at the top of High Street, a home he would enjoy until 1923, when he would sell the property to M.C. McGill. M.C. McGill would name this property Rest Haven, and he would have a board of directors made up of mostly prominent members of the Monroe community. A few people have been saying that it was not a home for the blind, but I say it was much more than that, for Mr. M.C. McGill would bring up less fortunate blind people from New York City, mainly New York City, to vacation here in the summer. A vacation they would never afford with transportation, meals, and boarding paid by Mr. McGill himself. It was actually a lifeline for these women for the 12 days they stayed in Monroe. For those 20 years that he owned the property, he spent $200,000 out of his pocket, which in the 1940, equivalent to 1940 inflation prices, it would be $3,500,000. Helen Keller, who was on the board of directors of the American Federation of the Blind, would visit the McGills in Monroe. She would also visit Rest Haven. In 1940, free, he would donate West Haven to the American Foundation for the Blind. The foundation would continue to operate the home until the death of Mrs. McGill in 1967. I have to speak of Mr. M.C. McGill and his work for many years in advancing the cause for the blind. Prior to 1911, his involvement with the blind was reading to them at the New York Home for the Blind. After that, he was involved in the Uniform Type Commission for the purpose of establishing a universal braille system in English. He was also appointed chairman of the New York State Commission for the Blind. After the end of World War I, he went to France to take charge of nearly 3,000 blind American soldiers and sailors. He returned to establish the Evergreen School in Baltimore, Maryland, to rehabilitate and educate these returning servicemen. The school would later be taken over by the Veterans Administration. He was responsible for instituting many of the state and federal laws, the legislation to help the blind. He was a founding member of the American Foundation for the Blind and is the first president in 1922, serving as its president until 1945, then serving as the chairman of the board until the year before his death in 1958 at the age of 92. He also was responsible for donating most of the money to the foundation for building the headquarters in New York City. Now, the house itself, I remember it well. The first 10 years of my life, I did live on High Street, 3 homes below the blind home. In the summer, you would always see the blind women going down and coming up High Street with their chaperones. They would go to the movies or have a soda in the village. At times, you would see them at Hall's Pavilion, which was today Alex Smith's Park at the beginning of Round Lake. There, one of the ladies would be playing the piano while the others would be singing. It was always a very festive time with them. This house that has stood on High Street for 150